Thank you all. My name is Carmen Icarino, an officer in the Lexington chapter of the Federalist Society. Thank you again for being here. As was alluded to earlier in the last session, this next panel addresses judicial selection in the Commonwealth. And moderating today's panel is a dear friend, John Roach. He's a longtime attorney with a distinguished practice, a graduate of Washington and Lee and the University of Kentucky College of Law. John is currently a partner at Ransdell, Roach and Royce in Lexington, Kentucky. And he's previously served as general counsel to the governor of the Commonwealth of Kentucky. He's also served as an associate justice of the Kentucky Supreme Court and has served as vice chairman of the Kentucky Horse Racing Commission. So thank you today, John, for moderating this panel.
Thank you, Carmine. Well, good afternoon. I wasn't here this morning, but the first thing I want to do is I think we need to have you all recognized Jeff Kaplan and all the work he's done organizing this event, but we need to do that. I've gotten to work with Jeff in Lexington, and I'm very impressed. So I'm going to introduce our panelists. Unlike some moderators, I've probably got a few things to say. I do want to, I'm sorry?
Oh, well, we better turn it on. So I'm going to introduce our panelists. They each have a brief presentation, and then we're going to kind of go into a free-wheeling discussion. I want to give a little statute of limitations disclosure about myself. Despite my opinionated personality, I've never spoken publicly or probably privately on judicial selection in Kentucky. I've always not wanted to look like a sore loser. When the voters send you to early retirement, I think you take the message and you go to early retirement. But I do think 12 years is probably good enough for a statute of limitation. And I do want to tell you all a story that's not ever been shared publicly, but those of you that knew Justice McAnulty, whose bust is at the entrance of the Supreme Court, who was a Supreme Court justice that joined the court when I was on it in 2005. He was the first African-American member of the court. Actually, in 2006, he joined the court. He and I agreed in private discussions, had we both won in the fall of '06, Justice McAnulty kind of representing more of a progressive liberal view of the courts and my conservative view, we agreed that we were going to travel the state and lead the efforts for a constitutional amendment to change how we selected appellate judges. He won, I lost, the plan went down the tubes. Justice McAnulty tragically had cancer and has passed away, but we both felt very strongly that it wasn't the way to run the railroad. When Jeff asked me to participate, I basically said, you know, I think after 12 years, people think of my viewpoint as it was, but I actually developed the viewpoint when I thought I was going to win. This is a great panel. We've gotten together before the panel. The people that have put this group together have really done you all a service. So let me tell you briefly about them. This is Chad Meredith on my far right. Chad graduated from Washington Lee University, went to the University of Kentucky Law School. He was the articles editor of the Law Journal, graduated in the top 5 of his class, and clerked for Judge Rogers and Judge Thapar, and then went to work at Frost Brown Todd, and then he reached his career pinnacle. It was a close pinnacle, but he loves the Judge Rogers experience and the Judge Thapar, but he came to work for Ransdell and Roach, my law firm, before he came and joined the revolution with Governor Bevin. Chad is brilliant. He is a fabulous lawyer, and he and Steve Pitt and Matt are working harder than any public servant should have to work. We also have Brian Fitzpatrick with us. Brian is technically a law professor at Vanderbilt, but is on special assignment to Harvard, where he teaches civil procedure. Brian clerked for Judge O'Scanlan on the Ninth Circuit and Justice Scalia. He did a significant material failure to disclose at lunch. He really only has one chink in the armor, and that is that he went to Notre Dame. But besides that, he is delightful. He's done a lot of thinking and writing about judicial selection, so I think you're really going to enjoy it. I'll give you a little preview of coming attractions. None of us agree, which is pretty interesting. And finally, we, all the way from Colorado, are just very blessed to have Meryl Chertoff with us. She is the Executive Director for the Justice and Society program of the Aspen Institute. She is a professor at Georgetown Law in Washington, D.C., where she practices around state government. Very timely topic in light of the last session. I've grabbed her out of the last session and took her through a tour of the Capitol a little bit, so we missed that. Meryl's been very active with Justice Sandra Day O'Connor and her project on state judiciary. Both of these folks on either side of me are Harvard Law, and this is a Harvard undergrad and a Harvard Law. So we've got some really, really engaging speakers today, and I think you're really going to like it. And then we're going to, they've all given me permission, well, I think they've all given me permission to interrupt them and probe them with questions even in their presentation, so we'll see how that goes. I'll do my best, Judge Rogers, former law school professor, Socratic method, the best I can. The shoe should be on the other foot for both of these law professors. But we're going to start with Professor Fitzpatrick. He's got a very interesting presentation, and then Chad's going to make some remarks, and then Meryl's going to make some remarks, and then we'll dive in.
Thank you so much, Justice. It's an honor and a pleasure to be here. Greetings from Nashville. I'm going to talk to you for a few minutes about the empirical research that's been done on how best to select judges. I'm going to go through the 4 methods that are used in the various states around the country, and I'm going to share with you some data on those methods, and then close with some data that I have collected myself. So let me begin with the judicial selection methods. There's basically 4 methods in use around the country. A small number of states use political appointment. It's much like the federal system where the governor nominates and the state legislature confirms. Political appointment was the original method used in the United States. At the time of the founding, all of the states used political appointment for their judges. Some states did it the way the federal system does it, and that is the governor nominates. Some states, the legislature nominated, and in some states there was a combination of the two. So that was the original method. Today there's only a handful of states that use political appointment, and some do it the way the feds do with the governor. There are 2 states, South Carolina and Virginia, where the legislature appoints all the judges and the governor does not have a role. Shortly after the founding, the states began to abandon political appointment and they switched to partisan elections. By the time of the Civil War, over 2/3 of the states were using partisan elections to select their highest court judges. Today, there are still a significant number of states that use partisan elections. I think it's around 10 or so for their highest courts. The partisan elections, as you can imagine, operate just like they do for other offices. The parties nominate candidates, and on the ballot it says which candidate is from which party, and the voters choose. In the late 1800s, partisan elections began to give way in the United States in favor of nonpartisan elections. This was an early progressive era reform. The progressives did not like partisan party politics, and so they thought, let's try to get rid of party politics and go to nonpartisan elections. The nonpartisan elections work much like partisan elections, except there's no party affiliation on the ballot. So the voters have to choose candidates without knowing, are they a Republican or are they a Democrat. Nonpartisan elections are still quite popular in the United States. I gather you have them here in Kentucky. There's a lot of states, over a dozen, that use nonpartisan elections today. The most populous method, though, today is this last method, the commission method. It's sometimes called the Missouri Plan or merit selection. It was conceived of at the end of the progressive era. The progressives were not happy with nonpartisan elections, taking the politics out of judicial selection. They decided there was an even better thing, and that was to turn selecting judges over to experts. That was a big reform of the progressives, was to try to make a lot of government run by experts, and they decided that the experts for picking judges were lawyers. Lawyers know best what makes a good judge. Let's turn judicial selection over to lawyers by creating a commission selected by the bar, and the bar will pick our judges for us. And many, many states, almost half, have adopted now the commission method for their highest courts. And the way it usually works is there's a commission that is picked. In many states, the bar picks the people. In other states, the governor picks the people. Some states, the legislature has a few spots. But the bar has a lot of influence over the commissions. And they send a slate of names to the governor. The governor has to pick one of the commission's names. And then at some point thereafter, there's usually something called a retention election. It's a yes-no vote on the judge. There's no opponent should the judge stay in office. And so that's the commission method. Now, in evaluating which of these methods is best, and I understand that you all use the commission method to fill interim spots on the bench here. Otherwise, you use nonpartisan elections. It's a common combination. A lot of states who don't use the commission method all the time, they still use it for interim appointments. Now, in thinking about what selection method is best, these are the factors that people usually talk about when they talk about what they want in judges and what they want in a selection method. They want a selection method that produces judges that have all of these characteristics. And so I want to just talk briefly about these characteristics, and then I want to tell you about some of the data that's been collected over the years about these characteristics in each of those 4 selection methods. So first of all, people, they like the idea of independent judges, judges that are not going to change how they interpret the law because the voters or the governor or the legislature or one of the litigants really wants the law to be interpreted one way or another. Accountability, you know, a lot of people want some kind of mechanism to express displeasure if a judge is doing something crazy or outside of the mainstream. We think there needs to be some way to hold judges accountable for the decisions they make. Obviously, competence, we want technically capable judges, judges who can understand the law and all of the sources of the law and, you know, read the precedents, understand how everything interacts with everything else. Diversity, a lot of people think it's very important that we have judges that reflect the racial composition of the communities they serve. Integrity, we don't want corrupt judges. We don't want judges getting bribed or other disciplinary matters. And legitimacy, we want the public to see judicial decisions as legitimate. These are the things that people typically say they want in their judiciaries. And so what does the data say about which method of selection does the best job on each of these things? Well, the first thing I'll say is this. I want to talk about independence and accountability first. So these are often things that figure very prominently in debates about judicial selection. The founding generation that created the federal Constitution believed very strongly, as we know, in independence. That's why federal judges have life tenure. Basically, no other judges in the world at this point have life tenure besides our federal judges. And so we know they felt very strongly about that. Accountability is kind of the exact opposite of independence. We don't want to give judges too much independence because we want to have some way to hold them accountable if they do things we don't like. These two considerations, they are, again, in tension with one another, but they also have actually very little to do with judicial selection. Independence and accountability are almost entirely about judicial retention. It's about what happens to a judge later on. It's not about how we initially find the judges. Independence and accountability are metrics for retention, not selection. And so we can match up any of those 4 selection methods that I mentioned on the previous slide. We can match them up with all kinds of retention ideas. We could give judges who are elected life tenure. That would give them a lot of independence and very little accountability. We could give judges who are appointed a 4-year term, then they have to be reappointed. That would give them a lot of accountability, not very much independence. So these two things have to do with retention rather than selection, and we could have lots of views on what's the best thing to do on retention. But I'm going to save those for another day and just focus our efforts here on what's the best method of initial selection. So I'm going to put those to the side, and we can talk about them later. What about competence and diversity? So there have been a number of empirical studies that try to ask the question, which method of selection in our states leads to the smartest judges, the judges that have the best credentials? We've looked at the law schools they've graduated from. We've looked at how much experience they have when they get on the bench. We've looked at how often their opinions are cited in jurisdictions that do not have to cite their opinions in other states to try to get at how good of a job judges are doing. And as far as we can tell, no system of selecting judges produces better judges in terms of competence than any other system. It's the same. Elections, appointment, nonpartisan elections, partisan elections, merit commissions, the judges have the same credentials and the judges have the same qualifications as far as we as researchers can tell. So there's absolutely no difference across the methods on competence. So that factor is a wash if we're trying to pick the best system. The same thing with diversity. There's been dozens of studies. It looks at gender diversity, racial diversity. There's no consistent finding that one method of selection produces more diversity than any other. And so both of those factors turn out to be something of a wash in terms of picking the best system. What about integrity is the next factor, and then legitimacy, the next factor. So there is some empirical evidence suggesting that the two elected methods fare worse on these two factors. There is some data showing that judges who are elected end up getting into disciplinary problems more often than judges that are appointed through the political system or through the merit panel. There's also some data that suggests that citizens in our states do not trust judicial decisions when judges are elected if they sit in a case where one of the parties has given them money or one of the parties has spent a lot of money trying to get them elected. So there's been a number of empirical studies that have been done where we ask people, would you see this decision as legitimate if the judge receives campaign contributions from one of the parties or lawyers, or that party spent a bunch of money independently to get the judge elected? And people say no, the decision is not legitimate. It's very hard to have elections where there's not campaign contributions, or at the very least, independent expenditures allowed. It's impossible under the First Amendment to have an election if people aren't allowed to do independent expenditures. So the data suggests that elected methods, the nonpartisan and partisan elections, fare worse than the other two systems on the integrity and the legitimacy factors for that reason. So when you get through all these factors, you kind of, in my view, if you're following the data, you end up in a tie between the non-elected systems, the political appointment and the merit system. And there's one factor that I want to suggest to you should break the tie. And the factor is this: which of these systems gives us judges whose viewpoints are representative of the states in which they serve? Now, sometimes the law is clear and it doesn't depend upon what kind of worldview your judge has. They're all going to reach the same conclusion. But sometimes the law is not clear. And the empirical evidence suggests that judges follow their own worldviews when they have to interpret ambiguities in the law. Republican judges, conservative judges, and liberal Democratic judges view things differently, not because they're doing something wrong, but because when there's ambiguity, we can't help but see the world through our own experiences. And this has implications for judicial selection because of this next slide I'm going to show you. This is a chart of the political leanings of lawyers in America. The left side of the chart is more liberal lawyers. The right side of the chart is more conservative lawyers. And what do you see? You see those bars are the number of lawyers in each spot on the ideological spectrum. And what you see is there's a lot more lawyers on the left side of the graph than on the right side. Lawyers are more liberal than the rest of us. The median lawyer is between Max Baucus and Andrew Cuomo. They're more liberal than the left of us, the rest of us. And what does that mean? Well, that means this. If you do not have a mechanism to screen your lawyer population for ideology, you're going to end up recreating that graph in your judges. If you just pass the lawyer population into the judiciary, you're going to end up with judges that recreate that graph. So the methods of selecting judges that screen lawyers for ideology will end up disrupting the liberal bias that might otherwise exist in a judiciary. So let me show you some data that I collected. This is each of our states from 1990 to 2010. This is all the appellate judges in each of our states. I looked at the campaign contributions they made over the course of their lives to see whether they were giving more money to Democrats or more money to Republicans. The states with bars pointing to the left are states where the appellate judges were more left-leaning than the people who lived in those states. The states with the bars to the right are states where the judges were more right-leaning. The vast majority of state judiciaries are more left-leaning than the people who live in their states. Kentucky can't see it because it's so small, but Kentucky's right up here. They're the 8th highest. There's a 30 percentage point difference in Kentucky between how many Democrats are on the appellate courts and how many Democrats there are among the voters of your state. So now why is this? Why do we have so many states where the judges are more liberal than the people who live in their states? Well, it's because two selection methods are really bad at screening for ideology. Nonpartisan elections and the merit system are very bad at screening lawyers for ideology. Nonpartisan elections, you can't tell from the ballot if the person's a Republican or Democrat. And so you're just passing people through without any consideration of their worldview. The merit system is arguably even worse. It's the worst in terms of skew on my chart here because the bar makes up such a high percentage of the commissions in most states. The bar is itself to the left, as we saw. It's the fox guarding the henhouse. The bar is screening for ideology from the bar. So those two methods, nonpartisan elections and the merit commissions, don't screen the lawyer population for ideology, and we end up with judges that are much more skewed to the left than we do in the other two systems, partisan elections, and the best system, the closest system to the people that they serve, is the political appointment system. The reason, by the way, partisan elections is slightly skewed to the left is because a lot of the partisan election states use the merit commissions to pick those interim appointments when the term has some time to go. So my suggestion is this: if we consider viewpoint representativeness as the tiebreaker between the merit system and the political appointment, the tiebreaker suggests that the political appointment is better than the merit system. Thank you.
Thank you, Professor. Very interesting. I would just point out, and we talked about some of these issues at lunch, from my perspective, and then we're going to hear from the other panelists, but just to throw this out to be thinking about it, probably what changed my mind were not the hot button issues, it was the criminal cases. I think you have to be an outlier type of an individual to be able to vote to reverse a criminal conviction where you believe there's been a constitutional violation from your particular district and in a particular case shortly before an election. It's generally not been a very good recipe for success in Kentucky judicial politics. And although I think a lot of and I think that that's where Justice McAnulty and I had kind of reached this common ground, was because you get a particularly tough case. I think it's very difficult. It's very difficult to stick to your convictions. But with that just little teaser, let's turn it over to Chad. Chad and the governor's office team is litigating probably more constitutional cases than any group of lawyers have done cumulatively over the last 20 years. So I'm sure he's got some opinions about this. And also he's involved in the interim appointments of judicial vacancies as it relates to being the Deputy General Counsel to General Counsel Steve Pitt, who's with us as well. It's all yours, Chad.
Thanks, John. First, let me say I'm thrilled there are still so many people here. I feel like this is kind of like the last race on Derby Day. So thank you all for being here. Second, I want to echo the sentiments of my friend Daniel Cameron back there. I also feel like one of these things doesn't belong here, and that's definitely yours truly. But I'm honored to be here on this panel. Thank you very much, Federalist Society, for having me. This is a very important topic, and it's a topic that I've wanted to have a public discussion about for several years. But what I've noticed is when you bring this topic up among Kentucky lawyers, nobody wants to talk about it. You know, maybe in hushed tones, they'll say, well, yeah, it's an issue. We might need to talk about this. But nobody really wants to have a public discussion about it.
Yeah, and Chad, actually, when you were on the bar convention planning thing, tried to get this panel for a couple of years, and it was always shot down. So that's exactly right.
That's right. And I think people have this mistaken notion that even discussing this topic is somehow disrespectful or insulting to the sitting judges, and it's not. It's not intended in any way to suggest that the judges that we have in Kentucky are not doing a good job. We have some wonderful judges. We have some very hardworking judges. But the reality is nothing is ever perfect, right? If we were all perfect, we wouldn't even need government. So what is wrong with examining our judicial selection method from time to time and asking, could we maybe do this better? And I think the answer is yes, we can do it better. And I think that probably a lot of judges would agree with that. I think a lot of our state judges would say, yeah, well, I think we can do it better, and let's explore some ways to do it better. Because my guess is if you conducted a confidential poll of our state bench, probably a lot of them would not be thrilled with the way the process works now. So I'm glad we're having this conversation, and this isn't a critique of anyone. It's a critique of the system and the perverse incentives that it builds into it. So because I clerked for Judge Rogers, and I know that you're supposed to give your bottom line up front, I'll tell you what my bottom line preferred method of selection is up front. I prefer basically what Tennessee has, which is where the governor appoints without any nominating commission. The governor just appoints a political appointment, as Professor Fitzpatrick said, a political appointment with confirmation by the state senate, and then I would prefer the judge to serve a term of years and then maybe have a retention election at the end. So how do we get there? I think the first question you have to ask is what should a judge be? I think you have to have a concept of what you want judges to be, and then design your selection method around that so that you can maximize the chances you will get the kind of judge you want. So what do we want a judge to be? Well, personally, I think, simply put, a judge should be a neutral arbiter of the law who applies the law as it exists, as it's written, without regard to the policies or results the judge personally prefers. Said a different way, let me quote to you. Leader McConnell mentioned Scalia Speaks earlier. Phenomenal book. If you haven't read it, I highly recommend it to you. Let me read you a couple quotes directly from the late Justice Scalia himself. Justice Scalia said, quote, "A judge must be, above all else, a servant of the law and not an enforcer of his personal predilections." He goes on to say, "The good judge must suppress his personal views and must decide each case as the law dictates, not as he would have resolved the matter if he had drafted the law or the constitutional provision at issue." So I think in a nutshell, that's what you're looking for. You're looking for someone who's always going to set aside their personal preferences and just do what the law says. And to paraphrase Justice Scalia, if you're a judge and you're not occasionally reaching results that you personally dislike, you're probably not doing it right. So how do we get to that point? How do we maximize the likelihood that we get judges who will do that? I think, to me, the answer is you've got to have a very heavy dose of independence there. I think that's probably the key ingredient. And how do you get that? You get that through appointments. The founders agreed. That's why the federal system is built on appointments. If you look at Federalist number 78, that lays out the case very well. And the bottom line is judges shouldn't be put in the position of having to worry that a particular decision is going to that they have to avoid angering a particular constituency or have to try to please a particular constituency. And if you have elections, then you've got that issue, you know. And, you know, I know that I've been in situations, I've litigated cases where I'm nearly 100% confident that judicial decision-making was made with at least a partial eye toward the issue of pleasing or not angering a constituency. And that's a problem. And I bet if we conducted a confidential poll of all the lawyers in this room, I bet nearly 100% of you would say that you've also encountered that as well. And that's a problem, but that's kind of one of the perverse incentives built into our system. Because we're electing judges, they have to kind of keep in mind, well, you know, what's going to happen down the road in the next election if I make this decision, or, you know, if I vote this way. And I don't think we want that in our judges. We don't want anything to incentivize their decision-making other than the law. And I think appointments maximize that opportunity. So why let the governor do it? Why not involve a commission? Well, I think commissions are problematic because, A, they don't take the politics out of it. As a matter of fact, I think they probably put more politics into it. And the problem with that is all the politics happen behind closed doors in smoke-filled rooms. So there's no transparency, there's no accountability. When there's one person making the appointment, you know who's making it, it's transparent, and it's accountable. If it's a good appointment, you know who to applaud. If it's a bad appointment, you know who to put the blame on. So there's transparency and accountability, and that is so important in government. And I don't think you have that with commissions like you do with appointments. And I'll add also, appointments obviously are what we have in the federal system. The individuals who drew up the federal Constitution knew what they were doing. They were some pretty smart individuals. It was providential that the greatest minds in political theory all lived at the same time in the same geographic area and all participated in making our Constitution. And it was just amazing. And they came up with the appointment system, and it's worked pretty well for them. So I guess the question then is, why would I call for retention elections for state judges? Why not just lifetime appointment like the federal system? And I think the answer, from my standpoint, is state courts and state laws have a much greater impact on the day-to-day lives of citizens than federal laws and federal courts. And state court judges are much, much, much more likely to come into contact with citizens in their day-to-day lives than are federal judges. So I think if a state court judge goes off the rails and does oppressive things or ignores the law or starts creating law out of whole cloth, I think there's a much greater likelihood of harming the day-to-day lives of citizens. So I think you need to have a mechanism built in that you can, when someone goes off the rails, you can rein them in. And I think retention elections allow that. But at the same time, they still give you that level of independence to just follow the law and not worry about the next election, because retention elections, judges almost always get retained in retention elections. So you're not going to hurt independence, but you're going to have a safety valve for the citizenry if a judge goes off the rails. And I mentioned Tennessee earlier. Let me add this tweak to the Tennessee model before I turn it over to my fellow panelists here. Tennessee only applies this method to appellate courts. I would apply it to all courts, trial and appellate. I think John would agree with me that it's probably a good idea for appellate courts. I think where we differ, I'm not sure where Professor Fitzpatrick falls on this, but I think where John and I differ is I would apply it to all courts. And why would I apply it to trial courts? Well, quite simply, trial courts drive everything in the judicial system. Everything starts in the trial courts, right? So if you can't count on your trial judges to follow the law, I'm not sure that anything else you do really matters all that much.
Well, my position, and then we'll turn it over to Meryl on that issue, is I think you have to have some political judgment to understand what's obtainable. I think people realize and know they vote for their local circuit and district judges. I can speak from experience that almost every person I met didn't even know they voted for the Kentucky Supreme Court. Most people that ended up voting don't even know they vote for it. And so the idea between Justice McAnulty and I was, look, the truth is when they did the modern judicial article in 1976, they did it that way because they didn't think it would pass unless they did. I mean, Cheryl Snyder will tell you that's not the way he would have designed it. It was a political calculation. I think if you undertook that effort in Kentucky, you're talking about some heavy, heavy lifting. And I think that since most people don't realize they vote for the appellate judges and they don't even know what the Court of Appeals is, they would be far more likely to give up that right to whatever system you wanted to change to. So that's kind of my view on it. I don't really have a position as it relates to district and circuit judges because I don't think it's politically attainable. So that's...
Yeah,
so
you might be right on that. I'm kind of talking about in a best case scenario if we got to wave a magic wand and design whatever we wanted, but you're probably right on that.
Well, let's bring us all down to earth and hear from Meryl, who has got extensive experience, probably longer than any of us, thinking and talking about these issues.
Well, thank you very much, Justice. My work on judicial selection began with Justice Sandra Day O'Connor. I ran the Sandra Day O'Connor project on the judiciary at Georgetown Law School for several years. Justice O'Connor was a great proponent of the Missouri system, or the merit selection system, which was a retention election system, and indeed she had, as a legislator, been one of the people who brought that system to Arizona. Hopefully in the CLE materials, which you'll take away today, there's some information from the Chamber of Commerce on some of the very fine aspects of the Arizona merit selection system. I want to thank Professor Fitzpatrick for talking about the historical aspects of this, because history is very important in the way that we look at this. The entire point of these shifts that occurred historically between governor-selected judges and elected judges was all based on anti-corruption concerns. So each time there was a shift, it was because there had been corruption in the system that had gone before it, and it's no different today. And one of the biggest concerns I think that Justice O'Connor had, and that we have to have right now, is the role of money in judicial elections. And a great deal has been written about that, but starting with the White case, Republican Party of Minnesota against White, there has been an enormous flood of money into the judicial elections. A little bit of data here in the 2015 to 2016 Supreme Court election cycle, political action committees, and social welfare organizations, and other non-party groups engaged in a record $27.8 million of outside spending, and 27 justices were elected in $1 million+ races in 2015 to 2016. Pennsylvania set a record of spending in that cycle. I think it was about $5 million just on those races. So those have become enormously expensive races. And I would say, as somebody who is a student of economic theory of law, I think that there's a very high wasted transaction cost. So personally, I just think that's a very bad use of money, which could be actually put to more useful purposes. What was this flood of money about? As you're probably aware, a lot of the social issues that were discussed were actually a surrogate between the great battle between the plaintiffs' tort bar and defense bar. And although the amount of dark money coming into these races makes it a little bit difficult to discern, it's probably the case that corporate interests are outspending the tort lawyers, but it's kind of a close call. So a lot of the money that's coming into these races has to do with concerns about the predispositions of judges to vote in business cases. The stalking horse for it is the social issues. And so it's important to disaggregate that in fact the ads which are run on criminal justice issues or reproductive rights or death penalty cases often are stalking horses for the real concerns about the people who are putting the money in, which are business law issues. So there are a number of problems which include weak recusal rules, which was the subject of the Caperton case, the party selection of candidates, which make it difficult for candidates to buck the system, and that was the subject of the Supreme Court's Lopez-Torres case, where the insurgent Democratic candidate in that case, who couldn't get onto the ballot in New York, her only sin was that she didn't want to have law clerks who were selected as a matter of patronage, and that's why the Democratic Party kept her off of the ballot. And then she challenged that, and in that case, in the Supreme Court, Justice Stevens ruled in favor of the states' rights position, but also made the observation that these can be exceptionally silly laws that the states ought to consider amending. And more recently in the Williams-Yulee case, Justice Roberts made a strong statement that judges aren't politicians, so that the role of money in these judicial elections can be really pernicious. Now, the good news in Kentucky is that you are not a very high dollar state for these races. Looked at the most recent data, and something like $488,000 was spent in the last cycle, which is lower than a lot of states, maybe higher than one contested race justifies. So it has not come here yet, but wait for it. If there are controversial cases, particularly business cases, it's on its way. What we've heard from the other two panelists, Professor Fitzpatrick seems to be mildly inclined to contested elections, and Mr. Meredith seems to be mildly inclined to gubernatorial appointment, not surprising from somebody who works for a governor. So I want to say to you, Chad, be careful what you wish for, because I understand, based on what I'm reading, that the Democrats are going to pick up 6 to 10 gubernatorial slots this year. That's what's anticipated, and you never know what's going to happen the next time. So you know, it's live by the sword, die by the sword on this sort of thing. And although I come from New Jersey, and New Jersey is probably the strongest governor state in the country. The governor picks everybody from the dog catcher all the way up to all of the Supreme Court justices. And we in New Jersey are a little bit smug. We think that we've got a great system. But our system certainly doesn't uniformly give us great judges. In fact, particularly at the trial court level, there have been problems from time to time. But the one cautionary note I would bring out of this is that Governor Christie got into a big fight over the reappointment of one of the Supreme Court justices. That seat sat open for 6 years. It turned into kind of a separating wound in New Jersey, and caused New Jersey, which has always been very proud of its gubernatorial appointment system, to actually consider whether they ought to change their system. So gubernatorial appointments, great, but remember also, if you get to pick this year, it may be somebody else getting to pick in another year. So what I am a little bit fearful of is that my good colleagues here may have a solution in search of a problem. I really think that the biggest problem is that you want to pick excellent judges. And based on what I see here in Kentucky, based on a little bit of research they did, you actually have a very good system right now for picking judges. You do have nonpartisan elections, which means that people go in not actually thinking that they're picking somebody because they are freighted with one political viewpoint or another, but they are picking the names. You have got, for these interim appointments, you've got a judicial review committee, which is pretty transparent. And it's composed of both lawyers and non-lawyers. It is forced to include one Republican and one Democrat. And so the actual way that these interim appointments are made with a pretty open system. Now, it could be even more open, and it could be even better. And for that reason, I commend to you this Arizona system, which I think that there are 13 people on that system. There are lawyers and non-lawyers. It's supposed to be balanced between Republicans and Democrats. And so you have a larger and more open system. One thing that is a little bit odd about Kentucky and a number of states is that while a lot of your judges actually don't initially stand for election. A lot of them are interim appointments that are made by the governor and are made by the governor with the input from these by this Judicial Appointment Committee. Now, that's a little bit of an odd system. I mean, if you've got something which is supposed to be an elected judge system, but in point of fact, the majority of justices on your Supreme Court right now were selected by the governor, and then they go into the election with the advantage of incumbency. So one question is that the best system where you have all of these interim appointments? And as I understand it, in a number of states, it's sort of a tradition for the justices to retire midterm to allow the governor to make the appointment so that when they stand, they'll stand already having the advantage of incumbency. So that's an open question and one that you may want to give some thought to. But if your concern is that you've got a few bad apples, then there are other things besides revising your state constitution. So the state constitution is what has the provisions here for judicial appointments. So one thing to think about is your disciplinary provisions, and another thing to think about is whether there should be term limitations for judges. And finally, what kind of information do voters have? And shouldn't there be better information about the people that you're electing to be judge? The phenomena you talked about people not even knowing who's on the ballot, it's called roll-off. You get to the questions down at the bottom of the ballot, you don't even know what you're doing. And so if you do have these information provisions in your local paper or being produced by League of Women Voters or by partisan organizations, that will provide greater information. And then just the last thing that I did want to raise is the question of should judges look like the population? I mean, the one caution I would have about that is the judiciary branch is the one counter-majority branch of the government, and the judiciary is designed to protect individual rights. So particularly in a strong governor state, you may want to think about whether, in fact, the judges ought to be a little bit different in their perspective than the people who are selecting them, and whether they ought to be a little bit more independent. And whether the data that we've seen here is reflective of the fact that the process of learning about the law makes people a little bit more rights protective as opposed to majoritarian in their instincts, because every one of us are occasionally a minority. It can be people who want to protect religious rights, for example, can sometimes find themselves to be in a minority. So saying that the majoritarian principle ought to govern is not necessarily, in the case of thinking about judges, always the best way to think about it. And with that, I'll turn it back.
Just a little historical background. So our longtime Chief Justice of the Supreme Court in the 80s and the 90s.
Oh, and our longtime Chief Justice of the Supreme Court, Chief Justice Robert Stevens, in the 80s and 90s, actively promoted the Missouri Plan, and in fact, it passed the House on numerous occasions to go to the constitutional ballot, and it was always killed by Senator Maloney in the Senate. Chief Justice Lambert did not believe in the Missouri Plan and did not like retention elections because, being somebody from the old Fifth, he knew there's nothing worse. There's only one thing worse than having an opponent, and that's having no opponent and having an election just about you. And as someone that used to run campaigns, like it or not, you know, you generally need to have an opponent. So we had a lot of discussion about this. Most people in this room that are under 50 don't remember these discussions, but the discussion of how we pick our judges was a prevalent discussion in Kentucky in the 1980s, led by Chief Justice Stevens. So I think that is interesting. The one thing I would tell the panelists and all of you is I don't believe and I think it's more accurate at the federal level, even though we don't like to say it, and I think in my experience it's probably more accurate in other states. The party labels in Kentucky aren't have not historically, even in the modern era, not been indicative of judicial philosophy at our appellate courts. So when I was on the court, I was viewed as the most conservative member of the court, but I was the most likely to vote in civil cases with Martin Johnstone, who was the most partisan Democrat on the court, who had the most partisan Democratic pedigree, and we were the most likely to vote. My two Republican colleagues I hardly ever voted with in civil cases. So I still think, particularly in the rural parts of Kentucky, outside of northern Kentucky, Lexington, and Louisville, the party labels are not as helpful. And in fact, the registration numbers, even though the state's kind of turned red, even in these local counties where they flipped red, they're still all democratically registered. So I do think kind of using out relative to kind of your studies and looking at that, although I think I do think that looking at donations is kind of interesting. I would point out that probably, Meryl, what's led me to agreeing to do this is, regardless of what the outside view is, I think that most Kentucky practitioners would tell you that we are in a crisis level at our Court of Appeals. I think that we can probably have a discussion about some of these political and constitutional cases at the Supreme Court, but from a commercial litigation standpoint and the family law cases, I think most practitioners have fairly confident in the Supreme Court, and but I think that level, it's not that they're not aware of who's running in these races. My position was they don't even think they vote for these races. I mean, and I think that it's even seat down. And then before I turn it back over for Professor Fitzpatrick's observations, I would also point this. I think that combined with however you select judges in Kentucky, until we get serious about a discussion about appropriate pay, we've got big issues. I think it's okay maybe if you're the circuit judge in Union County and they deserve more, but for Lexington and Louisville and northern Kentucky and now Warren County, and to expect people to be able to give up a law practice and to take the kind of pay cuts, and with obviously the changes, even though the judicial retirement system, but compared to the old days where they could at least hang on to that, I think that it raises pretty significant issues. But Professor Fitzpatrick, we talked at lunch. I said, in light of New Jersey, I'm actually for the New Jersey system. I think the governor should pick and the Senate should confirm. I would probably be so much for radical change that if you were afraid of the governor, because I'm for it either governor. I would have told you this in the Beshear administration. But if you were really nervous, I'd go for Virginia over the current system where the General Assembly does it. I truly believe the current system is not a way to run a railroad. I know they've all got problems. I think New Jersey's 10 years. You could argue towards the end they're going to start favoring. I think term limits. I think you need to have a 10 or a 12-year term and maybe two terms. But I feel so strongly about it, I'd let the General Assembly do it. Professor Fitzpatrick, anything you want to talk about? And also kind of tell us, if you were the king of the world, how you would design the judicial appointment or a selection system in the states.
Well, I actually agree with you. I don't favor contested elections. I do favor political appointment. I used to be higher on partisan elections. I was the law clerk to Justice Scalia when he wrote the Republican Party of Minnesota v. White decision, which held that judges running for election or judicial candidates running for election have First Amendment rights to tell voters what they think about the issues that might come before them. I used to be higher on partisan elections before the studies came out about campaign contributions and how the public perceives decisions in light of campaign contributions. And I think that elections are very hard to sustain in light of those studies. And so I do favor political appointment. I think my first preference, like yours, would be gubernatorial appointment with a confirmation by the state legislature. But I think my second choice would be legislative appointment. The one difference between the two systems is that the governor is one person, and so it's very easy to hold the governor accountable for bad judges. If you get bad judges through legislative appointment systems, it's much harder for voters to know who is responsible for these bad judges that we have. So it's much harder for them to hold the appointers responsible for bad judges. And so I like the concentrated accountability we get from gubernatorial appointments. So that is the system that I would favor. And I have one other observation that I want to make in response to, I think, some discussion we had today at lunch, and also Chad mentioned this in his comments, which is, you know, what we really want are judges who are just going to follow the law. We shouldn't care what their worldviews are, whether they're Republicans or Democrats, conservative or liberals. We just want people who follow the law. And I want that too. I think that's what judges should do. I think judges should just follow the original understanding of the Constitution or of a statute. But I think what judges should do and what judges end up doing are often two different things. It's very hard for us to separate from our subconscious what we think is reasonable in any given situation. And so I think we have a tendency, even if we don't want to, we have a tendency to see the world and see the law through our own experiences. And so I do think it makes a difference what the judges' worldviews are, even if we're trying to find people who are only going to be originalists. I think their worldview may still matter.
Yeah, and I think it's interesting to me. I like the accountability argument. I've got to tell you, we have a long history, Meryl, in this state in the modern era of taking the politics out of issues. For example, we have a Department of Education that the people of Kentucky think the governor's accountable for, but it's supposed to be independent. We have a Cabinet for Economic Development that the governor's held accountable for, but it's supposed to be independent. So I do like the idea that if you don't like what the governor's doing on pension or education or how he picks his judges, you get to go to the ballot box and vote him in or vote him out. There's something refreshing about that. I do think but Meryl, are you for the merit selection panel and then there'd be a retention election? Like, is that what they do in Arizona?
I'm actually agnostic. I mean, the merit selection system is a good one, and gubernatorial appointments can be good. The question is, who are being picked? Where is the advice coming from? Is that advice partisan or nonpartisan? Is it instrumental and designed to get particular results? Or is it designed to get the best judges? And I agree with Brian that what we want is we want great judges who will interpret the law as it's written and not be activist. The question is, how do we get those judges? And politicizing the process, making it be either a Democrat or Republican thing, and with respect, I guess this is a state where your instincts on that may not always, bear out. It's not necessarily that the Democrat will take a liberal position in a given case and a Republican take the conservative position. But what we want is great judges, and the question is, how do we get there? And what I would say is it's not so much how we pick them, but other structural aspects. How are they disciplined? What information do we have? If you're voting, you don't want low information voters, you want high information voters.
Well, I think what's interesting too, at least from my perspective, particularly at the highest courts in the state, is there's just no way to run the railroad but to allow the single justice to decide the recusal, because then voting blocks could get rid of you. So it sets you up in some pretty, particularly when there's campaign contributions involved. The case, the U.S. Supreme Court case out of West Virginia, Caperton. I mean, I've not read it extensively, but it makes me a little nervous because I would never. So that is. And the same thing with judicial discipline. I wasn't around long enough to kind of come up with my theory on that, but it is an interesting thought that if you buy into elections, that somehow unelected people can usurp the election, which is what we have a pretty aggressive judicial election discipline process. But what we say to, a legislator, I guess the legislature could throw them out. I guess it just they don't get disciplined that much, but it is kind of a unique situation, particularly at the highest court, because, the recusals are up to the person. The other thing that concerns me about where we are in the political dialogue in this country, which I'd like to hear, is I don't know if we're getting past the point where people are going to appreciate process versus outcome. And so, you know, I think that even on judicial elections where I've seen examples of maybe the Democrat losing where the conservative is taking a criminal case and saying, you know, this appellate judge put this murderer out on the street. Well, you know, that's pretty effective politically in campaigns. How effective is it for our constitutional order? So that kind of keeps driving me back that, you know, I don't really know the solution. I'd just be for something else. I have my own opinions about that. Would you tell us a little bit about what you think, Meryl, are the ideal kind of qualities of what's going on in Arizona in terms of their merit selection panel? Is it a panel that's for the whole state that's picking all the judges up and down? Is it a statewide panel? What is it about it that you think is a best practice?
So there is a statewide panel for the Supreme Court justices. What I like about the Arizona system is it includes non-lawyers. So that responds, I think, Brian, to one of your concerns that, you know, that lawyers, whether or not they skew liberal, they certainly skew to a guild mentality. So there may be certain things that are appealing to people who are lawyers who average citizens may view it differently. You also will be getting from the non-lawyers more of what is the behavior of the judge in the courtroom, if there's a track record on that. Do they have, this was an issue that came up actually in the Kavanaugh confirmation, some notion that Justice Kavanaugh didn't have appropriate judicial demeanor. And that's absolutely inaccurate. In 12 years on the bench, and there's never been any complaint about his judicial demeanor. I think that what people meant was, how did he present himself in a hearing when he was, frankly, quite angry? That has something to do with somebody's demeanor, but it's not their judicial demeanor. So, the question is, are we finding people to be judges who the public will view as being fair, as being educated, and as basically giving you a fair shake? I clerked for a district judge, and I remember one of the most meaningful things he ever said to me is, even though I know somebody's going to lose because I've read the papers, I'm going to hear every word they have to say in their argument because I want them to feel that they've had their hearing. Because if people feel that they've had their hearing, that's a good percentage of the process of providing justice. So those are the kinds of judges that we want. And obviously at the trial level, that's maybe going to be a little bit more important, and at the appellate level, some other things are going to be more important. But if you have a cross-section, they're functioning in a sense like a jury. They're functioning to wash out certain biases that each group have, and together collectively get a better result. And that's why I think a larger judicial nominating commission with an open process, with people having access, with very strict ethical rules for them. There are very strict ethical rules for the members of the panel in Arizona, so that gets rid of some of the cronyism that also might afflict it. It seems like a really good system.
Chad, why don't you make a brief comment, and then we'll take some questions.
Can I just say, I think in practical effect, it's going to be almost impossible to have a judicial nominating commission system where it's open and where there's accountability. I think in practical effect, it's really essentially in the long run going to destroy accountability, and it'll even if it's initially open and has transparency, I think over time those discussions will move to behind closed doors, and you'll develop voting blocks where decisions will be made before you get to the room. I just think when it comes to transparency and accountability, I think appointments are much better than the commission system. And let me just add that I agree with nearly everything Professor Fitzpatrick has said. My only slight disagreement would be with the New Jersey plan. I believe in New Jersey the governor has to reappoint after the term, correct?
Yes.
I would prefer retention elections if we were to redesign Kentucky's selection method for this reason. Now, I understand New Jersey has some kind of historical norms about who gets reappointed and who doesn't. Well, if we adopted a whole new system in Kentucky, we obviously wouldn't have that. So I think you would have a very difficult time convincing really qualified lawyers to want to be appointed by the judge or to be appointed by the governor, because they wouldn't have any confidence that if there were a new governor at the end of their term, they'd get reappointed. Whereas if you had a retention election, I think most people would probably feel confident in their ability to do a good job and get retained at the end of that. So that would be my one slight distinction with that. I think you'll get better quality people to want to do it at that point.
Well, in New Jersey, the cost of living is so high, sometimes they don't want to get reappointed.
Well, we're going to take some questions, but let me say this. I am just so glad that we've done this. I really think it's time to begin a discussion. I think that it needs to be thoughtful and respectful, and we can have different views. And some might think we don't need to change anything. Some might have more ambitious plans, and some might have different plans. Some might actually have plans that say if we're doing what we're doing, we could do it better. And I think that's probably true as it becomes, particularly to the transparency of our panels. But in any event, I think it's pretty thought-provoking, and we'll take some questions here. Yes, Judge Rogers. As long as it's not an international law question.
Well, now, John, you said there'd be 4 different views, and 3.5 of you are for governor's appointment.
Yeah.
I just point that out. I wonder, I sort of sympathize with appointment by an chief executive, because I don't think I have the personality ever to win an election, and I'm enjoying being a judge. The one, if you did have...
I would vote for you, Judge.
Thank you. I think if you had someone up there trying to defend Kentucky's system against, and I'm not saying I would be that person, but if you did, they might react to some of the generalities that are made about elected judges. Just, I would say nonpartisan, but nonpartisan or partisan elected judges. And that has to do with accountability and the fact that you need a lot of money, and money leads to perceptions of being in somebody's back pocket. All right, it seems to be the key thing. And I'm wondering if the Kentucky system isn't a little bit better situated to defend that by virtue of the fact that the people are elected from districts, which means they don't have to collect as much money. Not nearly as much money, because they only have the person who runs from Louisville only has to campaign in Louisville. I wonder if that would affect the degree to which the various panel members don't like election.
My prediction, Judge, will be that the next series of 6 to 8 year election cycles will see a big difference in the money in play. And I think particularly we have 3 districts where it's going to take, I think you're going to see $1 million+ expenditures in the next 6 to 8 years in 3 of the districts. I think that you raise a very interesting question. I think it's an excellent point. I also wonder, I would probably not be for changing it because of the political lack of. Part of me wonders what being on the Supreme Court, this is where I would differ with Professor Fitzpatrick in terms of this kind of viewpoint. I wonder whether that's the right way to design it, by simply saying we need 7 people from 7 different geographical regions in Kentucky, and why that should impact an outcome in a case. But again, I'm probably an outlier on that. What's your response, Professor Fitzpatrick?
Well, you know, I have to say I'm just curious how people are making decisions in a nonpartisan election where, number one, no one is spending any money to educate them about who the candidates are. Number two, you have no idea anything about the candidates' political views, Republican or Democrat, because they're not on the ballot. What are you basing your decision on? And if we had another panelist up here, Chris Bonu, who has studied judicial elections in great detail, he would tell you that nonpartisan elections are the worst type of election ever invented because voters have the least information in those elections than any other elections for those two reasons. People are not spending the same kind of money to educate them, and the most useful piece of information for any voter is party affiliation. It's like a trademark that tells that voter lots and lots of information very simply. And when you take those two things off the table, I would worry about what voters were actually picking the names based on.
Doesn't that go to competence, if you said it's neutral?
Well, I mean, I think that's right. I mean, there's no evidence that one system is producing more competent judges than another. That's right. But what are voters thinking they're picking is my question. Are they basing it on which last name sounds better to them? Then what is that opening the door to? If it's not incompetent judges, it might be another kind of bias.
And I also think if Justice Roach is correct, that there's some counterintuitive rulings by Democrat and Republican judges in Kentucky. So that those labels are not necessarily dispositive of how people are going to vote in particular types of cases.
Well, I mean, it's very interesting. It's to raise your question about the names. You know, Chief Justice Lambert, the long time, he served on the Kentucky Supreme Court for over 20 years and was the Chief Justice. His brother is on the Kentucky Court of Appeals, Jim Lambert, and his ex-wife is running for the Kentucky Supreme Court as Debbie Lambert, and I think is probably favored to win next week. So again, Judge Lambert's my friend. I like him. I've known him a long time, and I've known former Judge the Judge Lambert that's running for Supreme Court now was a former family court judge, and I've known her for years. But
so I guess this means in Kentucky, change your name to Lambert.
That's right.
Before you run for office. All right.
But it is an interesting. I couldn't resist it, but to say that.
The other question is there a way to educate voters better? And are voters going to bother to be better educated? And, you know, that's a jump ball. But if voters could be better educated, then they could make better choices.
Can I add something? I think if we're going to have elections, you know, Professor Chertoff said earlier that I think you quoted the Chief Justice as saying judges aren't politicians or shouldn't be politicians. I agree, but if you're going to have people run for office, they kind of are politicians, you know. So you need to let them educate the public on who they are and what they believe. And I don't particularly want partisan elections. I much prefer appointment, but if you're going to have people running for office, you've got to allow them to educate the public on who they are and what they believe. And with that comes, you know, spending money and raising money. And, you know, that maybe has some costs in terms of the public's views of legitimacy of the judiciary, all of which can be ameliorated by appointment, I think.
Well, I hear both of you, but I would stick with the current system before I move to partisan. I think that it does a disservice to judicial philosophy. I get what you're saying, but I have very little idealism left in me, as the people in the audience know. But I do believe that the art of judging should not be partisan. And I served with terrific Democrats who were textualists, and I served with terrific Republicans who weren't textualists. So that just scares the hell out of me. But maybe you're right.
I agree, John. But let me say this, though. And I'm not advocating for partisan elections. I don't necessarily think we ought to go there. But I think that view necessarily assumes that by identifying with a party, your judicial decision-making is going to be driven by partisan considerations. And I don't think that's necessarily true. I think the party label, as Professor Fitzpatrick said, is a very important trademark that tells people what you believe and who you are. But again, you can ameliorate all these problems with appointments. I mean, then you don't have to worry about raising money like you were concerned about. You don't have to worry about campaigning. There's transparency and accountability. It's a pretty elegant solution.
Well, with respect to transparency, let me ask you this, Chad. Would Governor Bevin be willing to put out a statement when he selects a judge as to these were the qualifications that I looked at, you know, and here's why I think that this person will be a fine judge, and maybe in a nominating statement. But is that a fair part of the process?
Well, first of all, I'm going to give the disclaimer. I'm not the spokesperson or communications director, so I don't pretend to speak for the governor.
If you were the czar.
If it was Governor Meredith.
If I were the governor, sure, I would tell people, look, this is what I'm looking for in a judge, and we're going to appoint these kinds of people.
Well, listen, this has been great. I can't stand moderators that go past the time. So if you have any more questions, just come up here. Judge Boggs, I'm sorry. We're past the 4. Judge Rogers stole all your thunder. I'm sure you're used to that. Anyway, sorry, Judge Boggs. I've never gotten over my questionnaire I had to fill out for you. Listen, thank you so much. Hopefully this is the beginning of a dialogue. Professor Fitzpatrick and Meryl Chertoff have come a long way to be with us today, so let's give them a big round of applause along with Chad.